Us today, and in today's live stream we're going to tackle the challenges of AI and business law, specifically how using AI creates new legal risks many C-suite leaders have never heard of, have no idea about, and do not know how to prepare. So in order to get into this fascinating subject, I have chosen two subject matter experts to help us figure out this emerging challenging and what we should do. Mr. Gary Keibel has over 2 decades of legal and business experience with an MBA from the prestigious Binghamton University and a JD from Brooklyn Law School. He is currently a partner in the Privacy and Data Security Practice Group of Davis and Gilbert LLP. Our second speaker is an AI best practice visionary, a CRM expert, and also the CEO of Sentia AI, Mr. David Forder. To our listeners, thank you for joining us. And if any of you have any specific AI or legal risk questions, this is the time. Please add it in the comments section. We also want to thank our YouTube and X viewers for joining us today. And please check out Sentia.community for AI tips, tricks, and the latest in AI news. Gary, would you be so kind as to tell us a little bit about yourself and how you went on this amazing journey to get an MBA, a JD, and now you're an AI and data privacy expert? It sounds like a fascinating journey.
Well, thanks very much, David, and I appreciate joining you here. Thanks for having me. Yes, I've been a practicing attorney for almost 25 years after going to business school and working in technology for quite a long time as an IT administrator. And now I'm at a firm practicing in the areas of privacy, technology, digital media, and all sorts of those new issues. My firm is a full service firm that does the traditional corporate labor and employment litigation and whatnot, but I focus on those unique areas. And it's always changing. I mean, when I first started doing this work, I was working more in digital media as that was really a new and burgeoning area. And then privacy started to creep in and become a bigger and bigger chunk of the work I was doing. And these days, AI is a very big part of the mix because just like privacy is everywhere, people are talking about AI everywhere and how to deal with these new services and legally how to deal with issues that have not been tested in this new AI world yet. So I really enjoy it a lot. It's fascinating. And it's certainly a lot more interesting than some other boring areas of law.
I can understand that. And it's also one of the things when I think about law, it's all based on precedent, and there's so little precedent. So it's like wild. I mean, if I'm a lawyer, it seems wildly exciting time. So that makes sense to me.
Well, that's great.
Hey, so if folks,
you're throwing the word precedents. I guess you've been watching Suits and things like that. So that's very good.
So if folks need to catch you and need your assistance, so they just go to the Davis and Gilbert website to connect with you?
Yeah, that's a good way to find me. The website is dglaw.com, as in davisgilbertlaw.com. You can find my bio there. You can also find me on LinkedIn. So there are other ways you can find me if you need to.
Fabulous. All right, well, let's jump right in, Gary. I appreciate that quick overview. So let's talk a little bit about IP ownership issues that are making businesses nervous about using AI these days. Like, who actually owns the data? If I put it into Copilot or ChatGPT or something and goes out there, have I lost control of my data? What do you think, Gary? Where are we at?
Sure. And that's one of the biggest issues that people ask about. And we need to break down the data into three buckets. There's the input data you might put into an AI platform. There's the output that you get as a result. And then there's the training data that the AI platform may use to learn in order to help generate that output. And there can be different ownership rights for all three of those, the input, the output, and the training data. Now, in terms of the data that you put into a platform, you certainly want to make sure that you have the right to use any information that you are plugging in. If it's confidential information from another party, you may not want to put it into a third-party platform. You could be violating a non-disclosure agreement. And you also want to look at the terms and conditions of a platform, which we'll talk about in a minute, because you want to protect your own ownership in what you input into a platform. Now, then we got the output that is generated. And what can you do with that? And who owns that output? Usually those terms and conditions for the platform will say, between the two of us, between the platform and the user, you user own the output. But what they're basically saying to you is that we have no idea who really owns this output. It's being automatically generated. It may be identical to output somebody else got. So we can't tell you what your rights are versus the rest of the world. But between the two of us, we will allow you to own the output. Now, you might then think, well, can I then get copyright protection over the output that's been generated? And the United States Copyright Office has made very clear that copyright protection, such as for a song, a painting, a novel, it only protects things that are created by humans. So if something has been created by a computer, it is not subject to copyright protection in the United States.
Interesting.
Now, copyright's just one of a bundle of rights that we have in the United States in intellectual property. There are trademark rights, right of publicity rights, patent rights, and these come up in the AI context as well. Same with the trademark. If you use an AI platform to develop a new tagline or a logo, again, between you and the platform may say you own it. But it's quite possible that that tagline or logo could infringe the rights of somebody else, and you could have a trademark violation. And the platform is certainly not going to guarantee for you that the output they generate is not going to cause you a legal problem down the road. So even though you get it from the platform, that's not an automatic license to then go use it in any way you want. And then there's right of publicity issues. That's the right of each person to protect the exploitation of their commercial image. Now, as much as I like to think I'm a famous guy, my image is not worth very much. But if you had an AI platform that generated an image that either looked like or evoked the image of some famous celebrity, you can bet that celebrity might come after you for a right of publicity violation if you use that in commerce to make money. So there are tremendous unknowns. And before I'll stop there in a moment, I want to say that it's really a good idea for you to control both your inputs and your outputs. I did mention training data, what the AI platform uses to learn, and you may not have insight into that, but you definitely have control over what you input into an AI platform. So be careful about what you input. And then the output, when you get that output, it doesn't mean that now you own all of it. You can do whatever you want with it, and it's not going to infringe someone's rights. There can still be risks with that output. So you need to clear that output and make sure it's appropriate for any use that you have planned.
Well, you're scaring the heck out of me, Gary. I don't even know where to start with this stuff. I mean, it's wow. Okay, so I can see where with stuff that we're doing, how it's going to really impact it. So I guess here one of the questions is when I listen to what you're saying, and I mean that list was so freaking long. It's almost like I need my corporate counsel just to make sure that I'm not doing something wrong and I have no idea about it. But when I look at all this legalese on these AI platforms, we specifically said who has the control in and out, who has the copyright. So do I just click agree when I grab these new AI software platforms and put them into my system? Or should I actually be reading the legalese and seeing what the data is? Because most of these, if I don't click yes, I don't get to use the software. So, right. So and do I need a lawyer to understand this stuff? I mean, most of us don't have the legalese knowledge to say, oh, well, what does that actually mean? You control my data or I do? That was gobbledygook if I ever saw it. Where is that threshold for somebody to bring in, I need Gary?
So not to make this a sales pitch, but yes, you need a lawyer.
Okay.
Contracts are important. Contracts mean something. And when you just click, I agree, and move on your merry way, you've just agreed to a contract. Now, if this were in a B2C context, there are different legal rules about whether or not that contract is enforceable. Is it something called a contract of adhesion? And there are ways to fight it. But if you're in a B2B context on behalf of your company and you go to a platform and click yes to terms and conditions, that's a binding contract. And it's not going to be easy to get out of it. So you do want to look at the terms of that contract and see what it says. Not to go into lots of war stories, but I had one client that came to me with a brand new AI platform they wanted to use that would record for HR purposes, interactions with employees. And we looked at the terms and conditions, and it allowed the AI platform to use that input data for any purpose they want. And then we realized this is really too much of a risk to allow it to have access to HR data about our employees when the platform can do whatever they want with it. So you do want to look at those terms and conditions and see what they say. Hopefully they say reasonable things such as, we're only going to use your input data for the purposes of generating your output. And as between us, you own the output. Again, no guarantee you're not infringing someone else's rights, but look at what other terms are there. I'm sure that the liability of the platform is incredibly low if something goes wrong, but you do want to dig into it. And that's not the only contract you should focus on. Again, lawyers focus on contracts and judges focus on contracts because that's what governs business. And when you sign your name to something or you click I agree, it means something. So let's say, for example, you were in some sort of creative capacity and you're working for a client and your contract says, everything I create for you, client, is going to be original and you're going to own it. Now I go and use an AI platform to create those deliverables. Well, firstly, it may not be original. So I may have breached my contract with my client by giving them something that's not original. And I don't know if I can guarantee to my client they own it. I made it on an AI platform who told me I may not even own it. So how am I going to tell my client that they own this deliverable? So what I've seen a lot in the industry is when AI becomes a significant part of some business transaction, which is completely fine, it's important to have that conversation and to have transparency with the other party so that they understand that, hey, we both have risks here in using AI. We can get fantastic outcomes. We can save tons of money. We can get unbelievably creative, but we need to be on the same page in terms of what are the risks from using a deliverable from an AI platform, because it's unfair for one party to shoulder the entirety of a risk that they really have no way of managing. So again, read those contracts, and if it's all gobbledygook to you, like David just said, then yes, you got to reach out to your lawyer and get some help.
All right. So I always thought that ignorance was bliss in business law. It's like, I didn't know. Wait, there's no precedent. How was I supposed to do that? I mean, the White House just in November came out with the AI rules and guidelines. So if I don't know, it's not illegal, right? I mean, what are our lawmakers doing and regulators, and how is this going to affect business? It seems like Europe, which I know is one of your specialties, is often like 6 months, a year ahead of these privacy and data concerns. Are we going to follow that path, Gary, or what is going to happen in America in the wild, wild west? Because I was nervous about AI law before bringing you on my show, and now I'm really worried.
Well, I'm glad I'm making everybody on this webinar sweat. That's my job.
It's working.
Always think of the worst case scenario and then try to protect you from that. But lawmakers and regulators are talking about AI all the time right now. David just mentioned, in the European Union, they are ahead of this. It's much like the privacy discussion. They were ahead of the United States, enacted GDPR back in, and took effect in 2018. And they just passed the AI Act in the European Union. So that's going to do a number of things regulating artificial intelligence in the EU. It's going to establish this new AI office. It's going to actually prohibit high-risk activities on certain AI platforms, such as using biometrics to discriminate against people in different ways. And then it's going to regulate other activities on a risk-based analysis. So the EU is jumping right into this, and they've already got a law, the AI Act, which is going to be phased in over a 2-year period. I think the first parts of it will take effect about 6 months after the law takes effect. What's happening on this side of the pond? We're a little slow to react. So the Federal Trade Commission, the FTC, is the one that often regulates things that will affect consumers. They regulate everything that they feel is deceptive or unfair to a consumer. So that can be advertising disclosures, privacy and data collection, and it can be the use of AI. And the FTC has been talking a great deal about AI issues. And interestingly enough, they testified in front of Congress about AI, and they basically said, we don't want to miss the boat on AI the way we missed the boat on privacy. So they would like Congress to enact some rules and some laws about this, but that hasn't happened yet. And quite frankly, I don't see that happening anytime soon. The FTC has put out guidance about AI. Now, it's very important to understand what guidance means from the FTC. It's not a law. It's basically their view of what is deceptive and unfair. So when the FTC puts out guidance and says you should do this or should not do this, it's not because it violates a specific law. It's because they think if you don't do that, you're being deceptive or unfair to a consumer. And the FTC is regulating just for consumers. They're not as concerned about B2B. So what they're concerned about with consumers is mostly transparency, that consumers understand when they're interacting with AI platforms, what that means for them, and also don't lie about using an AI platform. Don't come out with some product or service that says this was generated with AI and it really was not, because you may be deceiving a consumer into making a decision based on that representation. So the last thing I'll say is that the states will also get involved in this eventually. They haven't yet, but that will be the most complex situation if individual states start to enact laws around AI, because we have 50 states and it'll be very confusing for businesses at that point.
All right. So, when I listen to you, I think about one of the things that really keeps me up at night. And as a former CEO, it's like, what are my employees using AI that I don't know about, that I might be liable for, right? So to your point, if I know all my tech stack, and we're going to come and ask David some more technical questions on this, I know my tech stack. And if I've done my Gary, I've actually read it and I understand what the legalese, what they're doing with my data. But that stuff where my employers are doing stuff on my network, on my system that I don't know about, that's what's keeping me up at night. So if something goes wrong, if one of my employees is using an AI service, what actually am I liable for? And do I need to have HR or legal sessions with my employees to say, this you can do, this you cannot do. These tools are off limits for you to use on our network. If you want to use it at home, that's one thing. But here, this is what is that where we have to go? And can we actually do it? That's a point for data coming later. If it legally, that's the way to go. Can we actually technically do it? So sorry, Gary, go ahead.
Yeah, I think it's much like every other advancement in technology that you need to have a company policy and training so that employees know. I mean, it's no different than when we first got computers with internet access. Then companies had to come out with policies about how you are allowed to use access to the internet and then train the employees on that policy. Same happened with, smartphones. Same thing happened with social media. So it's important that employees understand what they are allowed and not allowed to do. So when it comes to an AI policy for a company, I've seen lots of different approaches. I've seen companies say, you may not use AI at all because it's too risky. And we don't know.
That's not realistic, is it, Gary? I mean, that they're going to do it. Come on. I mean, that's just.
Then the better approaches I've seen is you can use AI, but here are the controls. The controls may be you only use platforms that the company has authorized. If you're given a deliverable to a client, you're transparent to the client. You don't rely solely upon the AI platform for an issue of fact. I'm a lawyer, and you can Google the stories. There's been some bad, stories about lawyers relying on AI to develop briefs that they file with the court.
Yes, there has.
And that's a really bad thing, to submit a brief to a judge with a case that does not exist. With your license. So you need to look at your industry and decide, how is AI appropriately used for our business model? Then come up with rules of the road and then train the employees so that they know. And then maybe to your last point, David, if something goes wrong, the company may be responsible, but that really gets down to the issue about whether or not the employee was acting within the scope of their employment, or really went completely off the wall and did something that had nothing to do with their employment and the way they were trained and the policies of the company.
This sounds like the old gold rush in the 1850s here in California. It's not going to be the guys that create AI that make money. It's going to be the lawyers and the services all around the AI, where it's like all the money is going to be made, it seems like, because you are you are bringing out so many different issues that, I knew some of them, but it's like, man, there's so much we got to worry about. So Gary, this was really awesome. And I can see we can do an entire hour on just this stuff. But is there anything that you want to leave our listeners with before we jump into David's portion of the interview?
I would say with everyone is that, Look before. We'll come up with a lot of different taglines. Look before you leap. Be proactive, not reactive. Ounce of prevention is worth a pound of cure. You need to think about these things. Don't start using a service without talking to people internally in your organization, without talking to legal if you have legal. Ask the questions, have the conversation, and you'll get a much better outcome as a result.
So it seems like eyes wide open. You really need to think about this. Now, the other thing, I know that lawyers are extremely inexpensive. So would you go to a lawyer first, or you have somebody in-house maybe figure out and write all this stuff down and then come to you with questions? Because, I can see how this could be an extremely expensive endeavor for some folks that don't have a in-house corporate counsel, if you will, to do this kind of stuff. But I mean, it sounds like we don't have much choice.
I mean, it depends on the scope and complexity of your organization. If you're using AI for some very basic purposes, maybe just to give you ideas or something like that, maybe it's not a very big risky venture. But if you're a larger organization and you're using it to develop, deliverables to a client or some key business indicator for yourself internally, then you do need to talk. So it really depends upon the resources you have internally in your organization, the size and scope of your organization, and what the intended use of the AI will be for.
It sounds like sage advice, Gary. I really appreciate that. Hey, David, I noticed there's a lot of comments out there. Do we have a question, or were they mostly observations?
No, they're comments, but they're really, really insightful. So they're really
okay. All right. Well, please take a look at those comments, guys. I know that we have an AI CRM author that's joined us. So definitely some good stuff. Gary, well, thank you kindly for your section. That was fascinating. David, would you be so kind as to tell us a little bit about yourself, your AI experience, and I know you're a best practice visionary for AI, and you've been coming to this road for 7 years to get to now. But tell us a little bit about your background and your journey, if you would, please.
I wish it was only 7 years. And thanks, Gary. I noticed the title of the webinar is Perils and Risks, and now actually there's genuine perils. I knew about the risks. For those of you who haven't met me before, I'm CEO and founder at Sentia AI. Just a little bit of background for a minute or two. In a previous business, I was with a partner. We founded a company that grew to about 1,500 salespeople. I'm Australian originally. Don't hold that against me. We used a CRM at the time, Salesforce.com. The seat costs were a huge investment for us in that business, and we soon found that, like here in the US, sales teams are not huge fans of CRM. Most people used it. I didn't get a lot of return on my seat costs back then, and that really bugged me. So I started out on a journey more than 15 years ago to fix this. We determined what it would take to get salespeople to use Salesforce.com, and at the end result of that was our flagship product, Sentia, which completely changes the face of Salesforce and other CRMs now. When we launched our first version, we focused on a lot of machine learning and a whole lot of really neat algorithms and flows. But we always knew that we needed AI to take Sentia to the next level. And so we watched and waited. In 2015, I basically subscribed to everything OpenAI was putting out at startup, and we've been in this holding pattern waiting for AI to be commercially available. So last year, when it hit the marketplace and their APIs opened up, we were ready to go, plugged in the code base, and we've been off and running since. So we've been really early adopters of AI for businesses and in enterprise software. And we're at the cutting edge of all these risks that Gary mentioned and some others.
Appreciate that, David. Thank you. So we've kind of looked at the legal perspective of AI, and although it's amazing, exciting, it can do all these fascinating things, let's look for you for the business or the technological perspective of that. What are the serious risks that you need to avoid when you're implementing an AI outside of the legal stuff, just the technology part of it and how they talk to each other, spread that information? I mean, we have to face with this just the way Gary does from a legal perspective. From a technical perspective, you got to know what your system's doing in order to control it, right? I mean, what are you seeing?
Well, some of these risks overlap with things Gary said, and some relate to more the commercial risks rather than legal peril of AI. And I get that question a lot, like, what are the real risks genuinely now? AI, the first 6 months, it was a bit like the Wild West. Isn't it much better now? And the truth is not really. So if you're working in a large corporate, most of the large corporates have at least realized that AI use by their teams is inherently risky, and they may have taken some steps to mediate this. If you're not in a large corporate, there's a good chance your business hasn't yet done that. And there can be some serious issues with this. So we've all copy pasted information into ChatGPT or Copilot or Claude and asked it to rewrite some text or draft an email, or write some words for an article or a slide deck. If you're using a free version of these AIs, then all this text is actually absorbed by that LLM and can be regurgitated at any time for other people with really minimal work. Example, and Gary, I'm sure is aware of this, New York Times is suing OpenAI for breach of copyright because they were able to sit there and somewhat artificially manipulate ChatGPT to spit out New York Times article almost verbatim with a word-for-word match based on material it had absorbed into its neural network. And that means that if you feed information to these things and you're using free plans, it can do the same thing. So imagine this, you used it to help you build a proposal for a client, and one of your competitors is using ChatGPT and says, I would like you to build me a proposal much like company XYZ, my competitor. Anything you know about their business would be great. It's gonna feed all that out there back to your competitor, which is a serious problem.
Gary, I want to bring that up in our panel discussion with all three of us because that scares the crap out of me. Sorry, Dave, go ahead. I think that's super.
No. And I tell companies if they don't think that these AIs are being used this way by their team, I said to them, just imagine it's late at night, a guy's at home, he's got to have a deck or a proposal sent tomorrow, he wants to play with his kids or tuck them into bed, he's going to turn to ChatGPT or something to help produce this material quickly. And that's as I said, if it's on a free plan, then that's stored and learned and can be regurgitated for anyone else at the time. Other risks, AIs can obviously hallucinate and get things wrong. And if you're not really paying attention and you're just going with what it gives you, you may end up causing commercial embarrassment, loss of business. The AIs can plagiarize other people's materials, and you may not even know that that's what it's doing, which you then send out and claim this to be your own. There's other things. Now, if you do pay for these services, there's less of these risks, but none of these risks. And we can talk about those a little later. It's not going to blatantly share your data if you are on paid plans, but it can definitely still get things wrong, make mistakes, and there's other serious risks too, Dave.
Interesting. And I think from a technical perspective, we kind of just think data in, data out, but it's just not that simple. So, Dave, when we talk about Microsoft and Office licenses and stuff, obviously with the Copilot stuff and sticking it up on the side and it's like following you around and stuff by the Microsoft universe, where does it come as far as where is my corporate data being accessed with Copilot? Where is it going? And when it comes back, is it now mine, like Gary was saying, or is it depend on that Microsoft license? Because, nothing against Microsoft, but usually when they write licenses, it's in their favor, not mine.
Usually they didn't become the size they are by giving things away.
Just saying.
With a subscription, a lot of corporates are thinking, okay, I can tick the box on risk. I'll just pay Microsoft for access to Copilot. My team will have it there, and it respects our data model and our privacy models. And to a point, it's true. It's a little bit that way. It does protect the privacy of data somewhat, but there's a whole lot of other commercial risks with still using these sorts of paid AIs. For example, Copilot might be limited to keeping your company data from training its models, but it can still easily generate content based on sensitive data, passwords, personally identifiable information. I had to read that to get it right. That you wouldn't necessarily want to be published or circulated. For example, Copilot could generate a draft email for a salesperson, but include sensitive customer information without proper review. The AI will respect the data privacy model, but not necessarily that, Microsoft Copilot's not going to respect your company's policies or procedures about what should go in written material and what's okay to circulate. So if you're a salesperson, for instance, or a service team member, and you're generating emails for customers like that, you literally need to read them and go through them with a fine-tooth comb to make sure the AI isn't not only sharing private information, but it's not breaching any company policies. So that almost negates the use of them. So in reality, we all just are going to use Copilot and shoot the stuff out to clients. Cross-client data leakage is a serious risk. Gary touched on this somewhat. You may have NDAs in place with companies. So within the business can be allowed to see information on both companies' SharePoints, for instance. And the AI simply knows that you can see both companies' data. It doesn't stop it going and pulling information from one client and using it for another, which might violate NDAs and privacy obligations and damage relationships. A co-pilot could draft a proposal for one client that includes proprietary information from another. There's the risk of hallucinations and mistakes. So you need to read any of this material really carefully. And again, that we tend not to do that. We might give it a cursory once over, but nowhere near give it nowhere near as much scrutiny as if we've written it ourselves, knowing what the company would want us to put in there or not. And that can have really severe ramifications. Another risk is amplifying user errors. So it will train on your material somewhat. And if one person generates content for clients and there's errors in there, the AI will take that as a signal that that was correct and that was a good response. And so it will then potentially amplify those user errors and duplicate them with other people. As I said, policies are the biggest issue. The paid AI plans don't know your company's policies as opposed to what data it can view. So it's a real serious problem, Dave.
Yeah.
Yes, it sure seems like it.
If I could add one thing that I think is really helpful there, it's like the output from the AI platform, you have no way of validating where it came from and how it was generated. You talked, David, about the New York Times lawsuit, and they were able to do it in a way and then match it up against their own content. But that's what makes AI different than saying doing a Google search. You do a Google search for information, you see what websites it's coming from, and then you can evaluate, is this credible? Is this not credible? But that's the challenge with AI. You get fantastic output, but you have no idea what is the source for this data.
Yeah, and I think, Gary, the other point is Microsoft Copilot, not wanting to pick on that, whether it's that or a paid ChatGPT plan or Claude, it generates content so quickly. And when we're all really busy, it's human nature to just say, wow, I'm just going to use those 5 pages rather than read them through really carefully and fact check it all. So it's the ease and the speed of the content is the biggest risk with these things, because it's just, we all are in a hurry. And so if we had to sit down and write 5 pages about something, we would be much more careful about checking our facts than AI is going to be. And half the time it'll make something up trying to give you an answer that it thinks will fit your prompt.
That's interesting. So, Dave, one of the things that I think about is that wouldn't it be cool if I had my own marketing, sales, and my accounting numbers in one data silo, and I was able to put in LLM on top of that? Now, we've been told for years that you have to have huge amounts of data in order to make an LLM work. But wouldn't it be nice if you could do something like that, where you have your own company private LLM and I can lock it down? Is that something that you see happening in the future?
Yeah, and I think, I was going to talk about it a bit later, but that's what we do. So whether it's with us or with someone else, the only way to, and it certainly doesn't remove risks of poor content or commercial embarrassment, but the only way to mitigate most of the risks and make sure that the AI complies with policy as well as data privacy concerns is to have your own LLM. So we do that with Sentia. We have a product, My AI, and again, I don't actually want to advertise it, but we have a My AI by Sentia product where we can build your own LLM for you. It's not particularly difficult. It's to answer your question, Dave, you need an enormous amount of content to train a neural network. But once it's trained, you don't need an enormous amount of content for it to start adding value. It's all about the parameters you set it up with. So we set up siloed, private, dedicated AIs for each of our clients, and we can train those AIs not only on their data, their products, their services, their team members, how they style and what they write, but also the company's policies, what the AI should and should not put in material, in content, rather than just what the user has the rights to see, which is what happens with Copilot and paid ChatGPT and the like.
Interesting. Is that something that's commercially viable now, or is that something that's happening in the future? I mean, it sounds like the perfect solution, but is that technically viable?
You're forcing me to sell. Yes, it is. I mean, it's available now, so people can reach out to me, but we've got a bit more of the webinar to get through.
Got it. So Corey, you asked a question about what about requesting AI to cite its source. Gary was referencing how if you do in Google, it says here's the website and here's the information, right? I actually think that's not a bad idea. And I rather some of the comments that Michael has said about AI protecting you from AI. I like that idea. It's like you got a superhero AI protecting us over from those naughty AIs.
Yeah.
So guys, I really appreciate that. So now we're going to jump into Act 3, which is where we're actually going to kind of riff off each other and go over some of those ideas we talked about previously and kind of figure out what it is and where we're going this. So, I mean, the bottom line is you guys definitely have the battle scars, both the legal and the technology to work with both any company. So I see the biggest success forward going forward is blended AI or the interface of technology with humans. It's not just AI, it's not humans. I think the two together are the most powerful. So AI is becoming almost mainstream so quickly in sales tech. Do you see that as the future, or do you say that they're kind of branching off and humans are going to go here and AI going the other direction? Or what are you guys seeing?
Gary, do you want to comment?
I mean, I think you're going to see as people want to use it more, they're not just going to be comfortable with services that are completely wide open and no rules and no controls. To give you an example, in the legal world, people are talking about the use of AI with law firms a lot. And again, I cited those examples of someone submitting a phony brief by using ChatGPT. That's the example of what you should not do. But for those of you who ever deal with law firms, you know they use two products called LexisNexis or Westlaw. And each of those companies are developing their own AI services that will work within the confines of their own universe of information. And I think that sort of model is a fantastic model. It's just what you were talking about, David Brown, that, if you have a large amount of data of your own, and then you put AI on top of that, and it's able to do things with your own data or with data you trust that you couldn't previously, then that's a tremendous value.
Yeah,
we're going to see a lot more of that.
We when we do set up, Dave, an LLM for a client, we in the briefing for the AI, we make sure that it limits all of its. We can give a client the choice, but if necessary, particularly with something like LexisNexis, you can restrict the responses of the AI from the database you give to it. So you can say only respond to any prompt based on this material we've provided to you, and it will. Like, it really follows instructions to the letter. So if you say to it, I want to write a proposal much like my competitor XYZ's proposal, it will give it to you. If your competitors used it, it's going to give you their proposal. It tries to respond as accurately as possible to the English in your prompt. So if you set the AI up as a private AI saying only use the material we give you, that's what you'll get. It won't make things up anymore. The problem is when you use a commercial model, because it then will respect your data privacy issues, but it's going to try and answer your prompts based on the whole world of knowledge out there in the internet. And the question about citing its sources, Copilot does that now. So if you ask it to write an article about something or to summarize something for you, it will tell you where it got that information. But it doesn't mean those sites are correct. So you would have to that, click through to the sites, have a look at what it's pulled. It doesn't mean it hasn't hallucinated still. It just means there's some links there that you need to go and check the words it's chosen to reconstruct. So it's almost, is someone going to do that? Maybe. It might make everyone feel better to see it linking some sources, but unless you do the hard work to vet all that, it's almost next to useless.
So let me ask you both a question, and Dave, as the CEO, maybe you start with this and have Gary jump in. But it seems like we do need some legal assistance here to get a handle on this AI. And most corporations that they do need to figure out what it is that's being done, what it is being done that they probably don't know about, and legally, do they have to have training or something like that to protect themselves going forward? But I guess the most important question is, as a CEO, you've got 50 things that you got to do. Where does bringing in an AI legal review or AI legal assistance come in on that hierarchy of the top 50 or 100 things to do it? It seems like what I see is most C-suite is just like, we'll worry about that when we get farther along and they figure stuff out. And I'm hearing, no, that's not smart.
it's probably a better question for Gary. But as a I've been CEO of a couple of really large businesses in the past. I would even right away what I would be doing and what we've done in our business is make sure that everyone was clear about our company's policy on these things, whether it's paid plans with Microsoft Copilot, outside use in your spare time with free AI tools like DALL-E or Midjourney to generate images, whatever it is. I would make sure that my company's policy was absolutely clear to everybody and make sure that I've recorded this training, that they all know the policy and have committed to stick to it. And then I would also have everyone in the business, and it's actually a comment in the chat here on LinkedIn. I would make sure everyone in the business declared when they'd used AI resources to produce some material, whether it's a customer proposal or internally anyway, and make sure you know what's coming to you that may have had AI involved in the preparation of that material. Because if not, you're completely blind. Like you don't know how much it's used, how little it's used. Before you do anything else, you at least need to know how widely is AI being used, what AI tools are being used, where, and is everyone clear about what we feel is acceptable or not? And that's based on each company's risk profile. So a small business may be far less concerned, but they should still do the exercise of stating a policy and having complete visibility over just what people are doing and who's using AI and who isn't, and what is it? How reliable is it?
Yeah, I mean, it's about risk management and deciding, what activity am I using AI for, and what's the possible risk to my organization if something goes wrong. And there are certain activities that are going to be high risk activities and certain that are going to be low risk activities. Going back to what I mentioned earlier about the European Union's AI Act, that's exactly the way they approached it. They actually put things, I think, into 4 different buckets. They said there were certain activities using AI. It is so risky. It is so contrary to the interests of individuals that we're going to completely prohibit it. And then with other activities, we feel these are risky, they're high risk, but they're not impermissible. So we're going to put in place certain controls about what you must do. And then further down the continuum, there were certain activities where they thought, this is really not risky. It's not going to jeopardize the rights and freedoms of an individual. So we're not as worried about regulating those types of activities. So you need to look at all 3 together: the platform you're using, the business that you are in, and what outcomes you want to achieve.
Platform business outcomes. That's the legal perspective on that. So, hey, we've had some great questions here. And since folks have taken the time to write them, let's go down them real quick. And Gary, do you want to look at it? There's a couple where specifically you're asked, Michael Hudlow asked Gary, is there an easily identifiable point when AI assistance versus AI generated does not require special handling? It seems like a very gray area. I think this is a question for you, Gary.
Yeah, I mean, that's a very good question. And it's, think about what output you want. If you were asking an AI platform, what would be a good place to take a client for dinner that you want to impress on a Thursday night after work? All right, I don't think you need to worry about, that outcome too much. But, to both of your examples previously about a proposal that might be the same as a competitor's, you want to be careful about what you get. So it's sort of like you get what you ask for. You ask for a riskier outcome, then you're going to get a riskier outcome. You ask for a safer outcome, you get a safer outcome. And maybe I didn't say this as clearly earlier, but when you input those inputs into an AI platform, use generic words, generic phrases. Don't prompt the AI platform to give you something that's infringing, that's going to cause a problem. If you had an AI platform that would create artwork, you wouldn't say, give me a piece of artwork that looks like the following artist. No, you would say, give me a piece of artwork that looks like a beautiful sunset on the beach. Give them generic inputs, and then hopefully you'll get safer outputs.
I think that's a good point, Gary. I had a conversation about 6 weeks ago with a company officer who was evaluating responses to a request for tender, and they'd put out a RFT, and 2 of the vendors that had responded had obviously just copied the requirements from the tender straight into, and ChatGPT, I suspect, and had ChatGPT write their response, their proposal. So this guy had a dozen responses, but 2 of them were virtually identical because they'd just taken the ChatGPT version of the proposal and sent it in, and both of them had done it. And of course, he's like, well, I'm never going to use these 2 firms ever again now, even if they were the very best vendor in the space. It's going to happen. If you give an AI a specific prompt, like a copy paste from a request for tender, it's going to give you its best answer each time, and they're going to be really similar. But as you say, use generic words, you'll get a different sort of more creativity and more imagination there. So.
Yeah, exactly. And we're kind of hitting on the same themes again and again, which I think are important. But, in your example there about responding to the RFP and using ChatGPT to generate their response, one of the first things I would say is be transparent with the other side. If you're going to give them something that was just generated by ChatGPT, because like you said, they could identify that this is identical to somebody else's. But think about if those 2 responses were identical. One just submitted it, and the other said, here's my response. You know what? I used ChatGPT because I think it was creative for the following reasons and had interesting outputs. Well, the client might actually respect that. Because you were upfront and transparent about what you were doing versus someone that may be trying to pass off GPT's work as their own.
It's just you get down to these commercial questions of, I can usually pick when something's directly copied from a LLM, a ChatGPT response, and not modified at all. You can usually pick it, and there's AI tools that you can copy paste in an AI generated piece of content, and it'll rewrite it so it's a bit more natural language. But it's just so lazy. I think even labeling it as being generated by an AI is likely to, upset clients and customers. So you just need to. You can't take the easy way out with all this stuff. If you're going to use, and I use ChatGPT to assist me, but I always read this material carefully, and I tend to rewrite at least a third of it because it just sounds so mechanical. I think that's the crux of it. You can't use these LLMs to take your job from being 1 hour long to being 5 minutes long. You can do it to take a 1 hour job down to 15, 20 minutes. I think that's what you should be thinking. It's a great tool, and it's going to save me half the time, maybe not the whole time, and just use everything it spits out.
All right, so we got a couple of more questions here that I think we'd like to address. I think Glenn brings up something that I kind of, in the back of my head, think about, and it's like, to Dave's point, I don't think I send out anything that's 100% AI generated. I always tweak it, change it, and address it. But to Glenn's point there, are we legally protected, Gary, if we say this was AI generated? Or is that just like a velvet foil, if you will, where it gives me a little modicum of private safety, but it's illusory? I mean, how does that work? Glenn asked a great question.
Yeah, great question. And I'll give you the typical lawyer answer.
It depends. Okay. Pay me and then it depends. Okay.
Yeah. So think about, what the ultimate use is. So B2B context, and generating something with AI doesn't violate the contract you have with the other party or the spirit of the contract you have with the other party. I'm not sure, labeling, like I said, could be good for transparency purposes, but there's no sort of protection. If it's in the B2C context, you do need to be careful because, as I mentioned earlier, the Federal Trade Commission, the FTC, is really worried about consumers being deceived. And if you have AI generated outcomes and it convinces a consumer to make or refrain from taking a purchasing decision or other action, then the Federal Trade Commission would say you absolutely need to disclose this because you've now influenced what the consumer is going to do. So in that instance, maybe labeling it that it was generated with AI, while it's not going to protect you from all legal liability, it might protect you from some regulatory scrutiny because you've convinced a consumer to do something based on AI. And it could be the reverse. Maybe you have some sort of new product or service you're trying to sell, and you think it'll sound cooler to say that it was created with AI, but it wasn't. And then the person says, well, that sounds cool. It was created with AI. I'm going to buy that. I'm going to spend money on it. But you basically lied to them by saying it was created with AI. So you got to look at, as I said, it depends on the scenario. Labeling is not going to save you from anything, but that transparency may help you in a lot of different contexts.
I think I've got a hit list in our Confluence side with a long list of commercial products, usually software, claiming to be using AI when there's clearly no AI going on. So it's pretty obvious that everyone's jumping on this label, and because something you said, Gary.
So Gary, to Dave's point, and that was kind of where I was going too. So my head is this: marketing and advertising has a ton of fluffery. Let's just be honest, right? There's slight exaggerations, and then in the CRM space, there's lots of exaggerations, right? So legally, you brought up a very important point. So if I add, let's just say I have a marketing widget, and I say it's now Billy Bob AI, because I know more people will say, oh, it's got AI, I got to buy it, but I have no AI in it. I have some machine learning, some pattern matching, stuff like that. Is that illegal on the surface? And I know it depends, but
if it's going to influence someone, and yes, you brought up the one of the biggest issues in marketing and advertising law about whether something is puffery, and a puffery statement is something that really can't be quantified or measured. So when I say Frosted Flakes, they're great, that's puffery. If I said Frosted Flakes, they cure cancer, that's something you could measure and you could evaluate. So would it have an influence on the consumer's decision? I don't want to embarrass or name brands, but let's just use the tagline, BMW, the ultimate driving machine. All right, sounds like a cool car. If the tagline was BMW, the ultimate driving machine created with AI, well, then it might be, well, maybe I want to buy this car because it's been created with some new technology that might make it better than a different vehicle. Well, if that's what you're saying, then that better be true, because that's going to influence what the consumer does with their money versus just saying something is great.
On that, you just reminded me of something I was going to mention earlier too. Corporate can lock down AI. They can even have a private LLM through us, hopefully, and tick all the boxes. But then people are still going outside and using other services on occasions. Like I think of Canva and sales gen tools and lead gen tools, and they all have their own AI built in there. That's outside your corporate framework of protection. So if you go to Canva, for instance, and drop some text in there to have it help you build an image or a document, or you jump on a lead gen tool and they have their own AI, you're training those models. So you're not protected, as Gary mentioned at the start. You need to read their terms and conditions. But that's outside all of this framework, and that's going on in pretty much every product we touch in the business space now has some sort of AI out there outside the corporate framework, which is why it needs to be exposed and tracked. And you're training those models. Why not train your own private LLM from us, so that it becomes an asset for you over time? I just noticed there's one question there specifically about AI disclosure agreements from Todd.
Yeah, Tony has a great question.
I can't answer, but Gary, you probably can.
Yeah, Gary, could you add Todd? I apologize, I'm going to butcher his last name. SZAUNHUN has an excellent question. Would you be so kind, Gary?
Sure. So you're saying, are you seeing a demand for AI
Yes.
disclosure agreements between partners? Can signed AI disclosure agreements protect against infringement claims from third parties? Well, there's a couple of interesting things there. So you sign a contract or a disclosure agreement, that's between you and one other party. Whether or not you're infringing someone else's rights, you're not going to be protected from that. But you may decide, as between the two of us, who's taking the liability if there's an infringement issue. Am I going to take it? Are you going to take it? Are we going to share it? Or are we going to just be silent on it and whoever gets sued gets sued? So there's a lot that can go into that legal language. I saw very recently in a contract with a Fortune 10 company, it was about some creative services, and they had a section on AI. And their section on AI basically said, you don't use AI unless you talk to us first. And they were kicking the can down the road because they were basically thinking, there are a lot of issues here. We don't quite know how to address them. We'll address them when the time comes. So no AI until you have a conversation with us. And then, I don't want to say using AI is bad. They may love what you're going to do with AI, but they want to talk about it first so they can decide what are the appropriate controls are in place before we jump in. Again, look before you leap.
Yeah. Yeah, no, definitely good advice.
Wow, there's so many excellent questions here, but guys, I try to keep this down to an hour. So if I think about this holistically, Gary, I'm a CEO of a corporation. I have, let's say, 100 employees. This is something I don't have a choice. I gotta pay attention to this because whether I have AI inside of my business or not, it's almost guaranteed my employees are using AI on my network. So I do have to address this either piecemeal or in some fashion. I can't just kick the can down the road like you're saying and hope for the best, right? It just doesn't make, it's that risk assessment. Yes, if I kick the can down the line, I don't have to pay if there's a problem down the line, right? So is that like kind of the like kick the can down and if I'll pay for it later and hopefully survive kind of deal, or is what we call benefit analysis, right?
You want to jump in now and have a policy in advance and not find out afterwards they have an issue that, for example, one of your employees used AI for a deliverable to a customer and you billed the customer for 100 hours of doing work, not realizing the employee just took a shortcut to do it. And now you've got an issue with your client where you could say there's fraud there because you're billing them for something that did not really happen. So you do want to get in front of the employees. And though, we're kind of scaring people here with all the risks here, I mean, AI can be fantastic for your business. But it's about thinking about it in advance so you don't have a problem with somebody being upset afterwards.
Yeah. Just that last question from Nicole. Are liability insurers keying in on that sort of risk at the moment? Can you insure for the risk from to your business from use of inappropriate use of AI?
I'm not an insurance guy, but my guess would be that they are not there yet because that's really, I don't know how you insure against that that's a problem. But it does bring up an interesting issue. There was one AI platform that I had a client deal with, which had a free version. And it was basically, you're on your own, good luck. But they had a paid version and you could pay a higher amount for infringement indemnification from them. So they would indemnify you up to a certain dollar amount if their output infringed somebody else's IP rights. Maybe it was up to $1 million. So that's maybe sort of self-insurance. But I think it's a great question because it'll get there eventually. I mean, like I said, I've been in privacy law for a long time. And long ago, there was never cybersecurity insurance. And now that's ubiquitous with most companies in corporate America.
It's just a matter of time, right?
Yep.
So guys, we're running short. And again, these sessions, we're always really scramble to keep it under an hour. But I would like to end with one question. Brian Lambert just asked us, how do you see intellectual property law evolving to accommodate AI and also impacting invention agreements for employees who create for their company? And I think this is, Gary, this is a question for you, if I may.
Yeah, good question. I don't see intellectual property law evolving to help AI. I see AI trying to fit properly into existing intellectual property law. And it's possible that there are some laws passed in the United States or elsewhere that will deal with how AI products work with respect to intellectual property. But I do not foresee a big change in copyright law, trademark law, right of publicity, or patent law to accommodate AI. I think it's AI that has to accommodate the law.
Yeah,
that makes a lot of sense.
I mean, law changes obviously take a long time in any case, and you're exposed in the meantime. Thank you, Gary.
Dave, did you have any more points for that, Brian's question?
Not on Brian's question specifically. I mean, the invention agreements for employees who create their own for their company. I mean, I guess that's if you're claiming ownership of some material, you best own it. So using AI, I'm sort of reading the subtext of the statement. Using AI to build something isn't you building something. So it's a bit like the copyright mention that Gary said. So you're not building it. So you then claiming ownership of that could be a bit difficult. So yeah, if you're going to claim ownership, you need to have invented something rather than just have AI invent it for you. But that's all I could add, Dave.
All right. Well, look, I really appreciate both of you joining us today. As always, a fascinating session. Gary, your insights into the legal perspectives of AI both was exciting, concerning, and made me think that we need to look at our policies again. So if somebody has seen you today, Gary, and they'd like to ask you for assistance, they can catch you at LinkedIn, Davis and Gilbert LLP, the website. You also do a ton of trade shows. You do a lot of speaking shit, so they can see you a lot of different ways. Is that correct?
Yeah, it's actually possible you might see me in the real world.
And David, if somebody would like to ask you a question, what's the best way to connect with you?
Probably, I mean, given the, I'll put in the comments box here. I'll put a list of Gary's links and our own links. But anyone interested in for their own company, I'm going to do a plug. Anyone interested in for their own company and setting up a private LLM that's trained on their material, gets to know their team, it's siloed, reduces a ton of risk, not all of it, but a ton of it. Then send me a message on LinkedIn. Is probably the best way to get to me directly. Obviously, we have a website and email, but happy to talk, even if it's just a, well, what would that look like? You know, there's no obligation to discuss the thing. And along the way, I'm happy to give people some free advice on these sorts of issues, how to protect themselves.
All right, and same for myself. If anybody wants to contact me, please go to LinkedIn. You can find me there. You can also go to sentia.online and catch me there. But guys, I really appreciate your time today. I have a hunch we're going to have a ton of follow-up questions for this stuff because this, AI law is in its infancy in my mind, and the precedents that are going to be set and the directions. It's, if I'm a lawyer, this is an exciting time.
Yeah. And thank you for today, Gary. It was so informative. It was great.
Sure.
Happy to be
And
here.
it's also nice to work with a Binghamton alumni.
There we go.
All right. Thanks for everything, guys. Have a great day.
Is that like go Tigers, go Bears? What's Binghamton?
It's go Bearcats, right?
There we go.
Gotcha. I was close. All right. Thanks, everyone.
Have a great day. Thank you. Bye-bye now.